Another common question that we get a lot is if there's a judgment against me, can they attach or get to my wife's assets? And the short answer is yes. The way to look at this is your judgment creditors can get to what you own. And what your spouse earns belongs to you. The money that I make as a lawyer belongs to my wife. So if there's a judgment against my wife, they can get my income. That's because California is a community property state. And the same goes for assets that come from what I earn. For example, if your spouse is making a house payment, owned the house before you were married, owned the house before there was a judgment, and the spouse is making the payments out of their wages, that means that your personal interest in that house is growing. Every payment that's made gives you a little piece of that house because community assets, their wages, is going towards purchasing the house, paying the taxes, paying the insurance, etc. So a judgment creditor could put a lien on property that's not in your name, but that you have an interest in because of community property laws. So, and it doesn't matter when the judgment was entered. You could have this judgment 10 years ago, got married last week. At the point that they became your spouse, any community property that was earned at that point, typically wages, you have an interest in, and they can attach. They can garnish a spouse's wages. They can lien a spouse's property, so long as there's a community property interest in there. So, unfortunately, if you have a judgment against you, it's not advisable to get married until that's resolved, because that judgment could be enforced against your spouse that you just got married to yesterday. So the way to look at this is your creditors can get whatever you own. In California, you have an interest in community property, and they can attach it.